First of all, thank you for joining us. It's a pleasure to host you again, right? And especially today. Today is one of the most beautiful days for any privacy professional in the world, right? It's Data Privacy Day today, right? So what we're going to discuss today is a discussion on Joint Parliamentary Committee recommendations, because we have been seeing a lot of PDPB, but obviously we're going to see a new DPB, right? The Data Protection Bill. So, and I know you all are excited about it, and it's going to change the world for Indians as it has done for everywhere around the world. I think maybe one of the right places to be and to listen to. And this is a session which can help out a lot of people to get that basics, right? To also get technical there, but also get a lot of basics into what is it that actually everybody's talking about, or what is it that is coming out in papers, right? What is it? So you don't have to read so much. You can just ask all the doubts you have. Okay, so starting a session, right? So we have two more very prominent people here with us, right? So first of all, thank you both of you to take that time out from your busy schedule, right? And coming in and being able to speak to everyone for us, right? So thanks a ton for that. So Shashank Jan is here. Shashank Jan is head of legal at Vistara. And I know everybody has taken that Vistara flight already. So you already would know Shashank. So Shashank, would you also like to kind of take that, say a hi to everyone?
Good morning, everyone. It's a pleasure for me to join this session. All of these things are very, very new for us as well. So all of us are coping up. So it's interesting, to have a chat and to bounce off thoughts and discuss these issues and these points, because as you know, JPC is actually a lot more sweeping in comparison to what we have seen so far, because it's they're trying to target non-personal data also. So it's an interesting a topic to chat about, and generally to have a discussion with everyone, and all of us are data protection professionals, so it's very interesting for all of us, and all of us have ideas and thoughts, so look forward to a healthy discussion. And thank you, Akash and Tsaaro, for inviting me for this session.
Right. So guys, I just want to let you in one more thing, that Shashank also has deep expertise, right, in Asian laws of privacy as well as the GDPR. So if you have any questions on how to implement it, I think please feel free to post it to Shashank over the period of this webinar. Moving on to Pulkit Vohra is here. So Pulkit Vohra is DPO for British Telecom in Asia, Africa, and India. Pulkit and I know each other from like a long time now, and we have been in this field for, I think, when it started in India. So I think that is a story that we kind of share a lot of time. So you'll see a lot of us. I think we have already, a lot of people have seen both of us. So Pulkit, over to you.
So hey everyone, good morning again, and happy Data Privacy Day. So kind of the biggest week for all the data protection professionals in India, around the world. As Shashank rightly said, JPC's recommendation has kind of changed the way we have been seeing the previously called Personal Data Protection Bill. Really excited to what it brings into the table in terms of the new version, and really looking forward to this discussion. And thank you again, Akash, for inviting me.
Right. So I think I just gonna start just by introducing a bit about me, and then probably we're just gonna heads on to the questions and detailed webinar here. So we are a privacy consulting company. Data protection as a service is something that we do. We also have an academy where we kind of teach IVP, PCB, and stuff courses. And about me, I'm CEO and co-founder of this company, and also I'm FIP, CIPP, and stuff. But yeah, heads on to the webinar, and we're gonna know more about JPC today. So agenda for today is what is the timeline of the bill, right? Or just to understand once it comes, and how was the recommendation about the timeline. We're going to talk about it today. We're going to talk about what are the key JPC recommendations, right, that came out for the bill, and what is the way forward for everyone. Okay, I think let's start with a question to everyone. Okay, so basically you have 4 options to choose, right? Have you ever heard about this? Okay, not heard about it, just click no, right? You have some idea about it. Okay, this is going to give us context in how we're going to take this webinar ahead for you. Okay, you have some idea about it. I think I love the people in the third genre, right, where some idea is there, right? But definitely, I just want to tell everyone that everybody who says no for this webinar, they have no idea, this webinar is just for you. I think people have read about it, and I think some people have a fair idea about it. So I think we are very good today in terms of knowledge and people who have joined us. And I know very senior people have also joined this session. So okay, so timeline of PDPB, right? So okay, So Shashank, I think I'm gonna pose this to you and start this with you. And I know you and me and both have been kind of in this field, right, for some time, and we have been looking at some timelines. And the first draft came in, then the second draft came in, right? In JP. So would you like to kind of summarize that for our audience, Shashank?
Sure. So if you just see the timeline, and actually, I would take the timeline to a slightly further back as well, because 2017 is when the Puttaswamy judgment was given by the Supreme Court. But I'll just take a step back. So I think it all started with Facebook and people suing Facebook because Facebook was treating the data as if they own it. And after that, the European Union and European Commission and all of them, European Court of Justice, they sort of ruled that no, Facebook, you don't own this particular data, and the ownership vests with the individual. And it started sort of over there, where data porting and all of these things, and giving ownership of data to the person who owns the data, is something it all kind of started. Taking from there, obviously, GDPR and all of these laws have developed. And then after that came this Puttaswamy judgment, in which basically Article 21 of the Indian Constitution was read into, and it was interpreted that right to personal data is part of right of life, and therefore it is something which must belong to the individual, and the government needs to do something to give these rights, because the IT Act that we have, which is the Information Technology Act, was grossly inadequate and did not deal with these particular aspects. And in effect, the IT Act basically just required an organization to have a data protection policy, and that's about it. And that was good to go, and no further real compliance was required under the IT Act, and that was found to be inadequate. So the court recommended to the government that you establish a committee or something, come up with a bill. And that's when Justice Sri Krishna committee was constituted, and there were several readings of the and iterations of the law. There were the reports were submitted to people. The draft bill was put before the cabinet, and then after that came all of this Joint Parliamentary Committee, which sort of started to examine the bill. And they had ideas of their own, and they decided it's not adequate enough to have aspects relating to personal data, but it should cover non-personal data also. It's something which needs they basically brought in an entire angle of national security, if I could say, to sum it up into the data protection bill, in addition to the non-personal data protection. And they want to regulate they want to get entities to establish organizations here in India, have offices here. They want data mirroring, retaining of data here in the country. So like a host and a whole bunch of measures. And that's something that's led to dissent from MPs, especially from Trinamool Congress and from others. And that's mostly generally on the basis that at the moment, the law is governing both government, state, and non-state actors. And the government has the JPC has recommended that there should be a carve out on account of protection of national security again, and to prevent social disrest and all of that. There can be certain government agencies which can be excluded. So that's basically the dissent, and that's the main focus of dissent, if I were to put it in one line. So that's generally the timeline. And obviously after this JPC, as Akash rightly put it, it's basically means rewriting of the whole statute and doing fresh line of thinking. I personally don't think that it was really required to go all guns blazing in this particular manner, because it's easier to deal with. I'm not saying that these are not issues, these are certainly issues, but they could have been dealt with in a bite-sized manner instead of tame the big bull. It would have been easier to. So yes, Syed, I'm saying that it is not in the same line as other countries. It is certainly different than what other countries are regulating. You see California data protection or EU GDPR, they're more focused on personal data. The JPC wants it to expand it to non-personal data. as well, and have a and bring in a national security angle into it, where the government basically has the ability and the right to police information and to um, do a host of things. That's the recommendation of the
Definitely.
JPC, I could put it.
I think probably very well fair put in terms of timelines as well as what has actually happened. I think that kind of summarized also for a lot of people about JPC. I think I'm gonna move on from this to kind of put and talk about some detailed discussions on what are these key JPC recommendations. So I think Shashank kind of has already talked about scopes for all of you, that scope kind of increased, and earlier scope was only personal data, now the scope is also NPD. I think probably moving on to the next scope, that is transparency, right? I think Shashank again kind of pointed out saying one of the things is that government kind of coming in and wants to put in a national security angle as well in there. But still, I think I'm talking about transparency, children's privacy, and implementation stages, right, Pulkit? So Pulkit, what are your takes on these recommendations in terms of if we move on from scope and then go directly to transparency, children's privacy, and so what are these key recommendations?
So, I mean, if you talk about the recommendations around children's privacy, Akash, the JPC has suggested that, first of all, the data fiduciaries who are exclusively dealing with children's data in India, as you know, the children's data means data of anyone less than 18 years of age. They have to register it with the DPA. They would automatically be classified as significant data fiduciary. And the third thing that they have recommended is, and that's kind of important, like, and kind of strange, according to me, that 3 months before the child attains that majority, means he becomes 18 years of age, he becomes an adult. The data fiduciary has to inform the child. You have to provide the consent again once you attain the majority. And Shashank, you can come in here with your opinion, but I don't see a point of why they would do that. I don't see the reasoning behind that. It's just complicating the consent mechanism, in my opinion, that you have to be still would have to devise a mechanism to rearrange for the consent from all those minors who are going to attend the majority, keep a track of their ages when they are attending the majority, and then get the consent again from them. So that's around the children's privacy. In terms of the implementation stages, first of all, and that's something I really liked about the recommendations, one of the few things, unfortunately, is that they are saying that bill will be enacted in a phased manner. What it means that ultimately the data fiduciaries and the processor would have 24 months to comply with the requirements of the data protection bill, much in line with what we have seen in GDPR. It also gave us 24 months of the grace period. And within that 24 months, there are different phases that JPC has recommended that after 3 months, DPA has to be constituted, its members have to be, member committee has to be formed. Then by 9 months, they have to, after 9 months, the data fiduciary should start registering themselves with the DPA if they are classified as significant data fiduciary. And ultimately, as I said, after 24 months, all the data fiduciaries and processor who are operating in India have to start complying with the requirements. What I would like to see in this phase manner, and that's something the JPC has not mentioned, is once the DPA is formed after 3 months of the bill is passed, as per their recommendation, the DPA has to start issuing guidelines and procedures of how to best comply with the bill, because there are still a lot of uncertainties. We don't know what critical personal data is, for example. So the JPC has not said anything on that, but I would really be keen on looking forward to DPA being active from the day one in terms of issuing guidelines and best practices. In terms of transparency, I mean, it's more related to the algorithmic fairness that the JPC has kind of pointed out, that the organizations who are kind of processing the data about the citizens of India, with the help of machine learning algorithms or artificial intelligence, they have to be transparent with the data subjects in terms of what algorithms they are going to use. That could be, again, we have to see how it kind of lays out, what are the guidelines for the DP of how we make sure the algorithmic fairness is there. But what I would assume that it means that you have to kind of indicate what kind of algorithm you are going to use in your privacy notice when you're collecting the data from the data subject, if you're going to use algorithms. So that's being more, I would say, algorithmic transparent to the data subjects.
I think consent became more difficult, right? Age-based consent made it very difficult for us. I think one point that kind of took it from you. I think one of the good things that is there, I think again, summarizing the discussion is that we have 24 months to do whatever once the law comes in. We still have a lot of time to figure out. I think the third thing that kind of put through is was also phase wise. So I think that is something that no, I was not thinking about Pulkit, but I think that's kind of very fairly put that if we are putting the law out in a phase wise manner, let's say for personal data first, then NPD, and then maybe in next 3-4 years we kind of put in all the fences, right? And even if we can call it national security, we call it compliance, whatever you call it, but if we have more grace period, then I think for a vast country like India, I think it will make a lot more sense compared to other countries, right? Okay.
Just
So
coming to children's privacy, which Pulkit was mentioning. So there's actually logic in what the JPC has recommended in taking consent, because under the law, under the Indian Contract Act, which applies to all of us, any contract that you enter into with a child is a voidable contract. That what does that mean? That means that the contract is valid up till the time the child does not decide to rescind that particular contract. And as a practical matter, we do this in our company already. Like, for example, we have people who are a part of our loyalty program and things like that, and they enrolled into the program as a child. So after that, we do obtain consent from them, and it's natural, and we are obliged to do that. Even if it were not for this statute, we would do it, because as per the contract act, there's no contract. The contract is voidable with a minor. So therefore, out of utmost caution, we would take consent. Now, there could be ways around this, and to deal with this kind of a situation. One of the easier ways to do it is a deemed contract kind of a thing, that you send an email to someone telling that person that, look, you became our member on XYZ date, and you were a child at that point in time, and now you have turned major. So if you do not wish to continue to be a part of our loyalty program, for example, then please click on this button. If you don't click, then in that situation you will continue to remain our member, and however, you have rights to opt out of the program at any point in time in any ways. So that would be a way to deal with it. Obviously, the devil lies in the detail, and what sort of is put into the statute, because these are all just recommendations. It's not necessary all of this will translate, but as a practical matter, this is how any good company would be dealing with this particular action. I think the real problem with this children's privacy is telling companies which exclusively deals with children's data be requiring registration. So just to get around this particular thing, some company could just register 1 or 2 people, because then it's not exclusive children's data. It could just register 1 or 2 adults, and you just get around it. And it would be very unusual, and there would be a very, very narrow set of companies which have only children's data. And I can just put this into perspective very easily. So even if there is a company, for example, there's a company which is manufacturing babies food, and it is collecting children's data, it will never be collecting exclusively children's data, because it will have data of its employees also, right? And its employees are adults. So effectively, this recommendation doesn't mean anything, because it just simply wouldn't apply and work as a practical matter, because there will be no company out there which would be dealing with children's data exclusively. So I think it's not the recommendation, at least to this extent, and some of the other recommendations, as I see it, have not been fully thought through. There's also a question around back offices, which says that India is processing data of other countries. So this law will actually not end up applying to them, because if you see, this particular law, it will be for Indian residents, because it's the Indian residents, as per the Indian Constitution, who have the benefit of this. Statute is flowing eventually from Indian Constitution and from Article 21 of the Constitution. And the Constitution as such applies only to Indian residents, which includes, of course, citizens and people who are otherwise permanently resident in India, which is a 180-day definition as per the current law. So it would apply only to them. So if those IT companies are exclusively processing data of foreigners, then in that situation, this law will not apply to them.
Shashank, except that those back offices would definitely have employees in India, right?
Yeah, I
So,
agree. So to that extent, it would apply for their data, but not for the foreigners' data.
yeah. Yeah.
So let's go on to a few more ones, right? So we have right to portability, we have cross-border data transfer, we have reporting data breaches, and we have rights of the deceased. Okay, so I think let's kind of get in with Shashank. And Shashank, would you like to kind of take a few more here, the JPC recommendations and how they're going to affect everyone around us? Yeah.
So I think cross-border data transfer is kind of interesting because there are very interesting requirements that have been put over here, and that's basically requirement of mirroring critical and sensitive data and keeping that over here. There is a requirement over here that these foreign companies need to have and must mandatorily have some kind of an office or some kind of a presence in India. There needs to be a mechanism where within a certain period of time this data has to be brought into India. I think a lot of these things are very inward looking kind of recommendation, and we have to realize, and what the committee has not really thought about, that as a world we have grown, and we have progressed because a lot of this is due to globalization, and globalization is to a large extent responsible for where we are, and it's contrary to that, because there might be certain countries which are very efficient in doing certain action. India is of course an exception because we are a large country, and as such we have a lot of resources and things to deal with it. But to impose these kind of archaic kind of recommendations is not great. It's not that a Facebook or any of or Instagram or any of the big data companies, they would kind of exit India or anything. They'll find ways around it. They'll find work around this. They'll probably end up doing certain of these actions. But all of this at the end of the day comes at a cost. And that cost is something which each of these companies will be looking to recover, and it will be from customers like us. Now, for example, they talk about establishing data centers and data storage and all of these things here. All of that is like a huge infrastructure investment. You require reliable and cheap electricity to have all of those capabilities here in the country. There are a lot of logistics and infrastructural challenges which we need to which will need to be worked around. So if you, for example, think about it, where a good chunk of the country still does not have access to continuous electricity, and you're wanting to divert that precious resource to a data center just to keep this particular data in India, it doesn't really make sense, because like data privacy and all of these things are great, but you have to think of it, that what is it that the country really wants. Do you want to give electricity to the farmers and to people in rural India for their daily needs, or you want to divert that electricity for securing data? So it's a lot of thinking through which needs to be done. These are well-intentioned recommendations, but you have to think of it, that what the country can afford, what it can't. Similarly, for example, on data portability, right to forgotten is something all of us are very familiar with, that which the GDPR has brought into force, and is something which other countries are also adopting. Data portability is, I think, an interesting one, because how do you port data from one entity into other? Like it's just sound very strange to me. It's not like a mobile number. It's not something tangible which can be ported. There are data fragments which could be like at n number of places, and it's in itself a Herculean task to delete data and to manage data flows and to do all of that. So to think about it, it's kind of really going to be difficult. And like the bigger companies might be still be able to support and to do this. If you think of it from a practical perspective, a smaller company and a smaller organization or an upcoming organization, it would be very, very difficult to achieve these kind of things. I know there are carve-outs in the bill in its current form for smaller companies and organizations, but the minute you cross that particular threshold, this is an expensive exercise. And at the end of the day, it again comes to numbers, and everyone is going to be looking at protecting their bottom line to sort of deal with it. I'll let Pulkit take the other two.
Sure, Shashank. And just to before I come to the other two, just to point out some other things around cross-border transfer of data. As Shashank said, it's really interesting to see how organizations comply to that, because it's a huge cost factor for them also to kind of try to find out a solution to kind of host that sensitive and critical personal data in a scenario where we don't know what critical data is right now. But other than that, when the JPC has also made some recommendations around the restrictions of transferring the sensitive data outside the country. Now they have said that okay, you can have the some kind of India version of SCCs or an intra-company contract, but then it has to be approved by the DPA, which will consult with the central government whether those SCCs that they are planning to build or the intra-company contracts are good to be approved or not. So in that sense, JPC has recommended that DPA does not have that independence in terms of deciding what SCCs would be best suited for the companies in India. They have to consult with the central government. And then those SCCs and intra-group company contracts, or basically BCRs, they cannot coincide with any state and public policy. So what it basically means that you can't have a BCR or you can't have a SCC which kind of contradicts any of the existing state and public policy. Again, it's very subjective of how would they interpret what state and public policy they mean. But it's kind of again a restriction that we would the organization would need to be aware of when they are transferring sensitive data outside the country. Around the data portability, again, one additional point that the JPC has recommended, that the organization cannot give an excuse of trade secret in denying a request for data portability. So they have kind of really tried to emphasize on the rights of data subject, which is good. And then on the reporting data breach, this is again another good thing that I felt was there in the recommendation, that it came close to what we have in GDPR. Like they have now defined the timeline of when the data breach has to be reported. So it's within the 72 hours time frame that the data fiduciaries have to report the data breaches to the authority or to the data subject if it causes a significant harm to their rights. So previously in the existing draft of the bill, we don't have that clarity of that timeline. So JPC has recommended to make it 72 hours. Rights of the deceased. So this is nothing but a right given to a person that they can. So you have that will system, right? You create a will. So similarly, the individuals have a right to kind of assign a legal guardian or a legal contact if they pass away, unfortunately, and then they would that legal representative or a legal heir of that deceased person would have certain rights, that they can ask the company to stop processing the data. They can change the terms of the contract that is there between the deceased person and the organization.
I think we're very fair to kind of summarize a lot of things. I can see a lot more questions here in the chat, so I just want to take one of them. Everybody loves talking about controversies, isn't it? We start with like, these are the things that are going to become controversial. Okay, I can see some masala here, so I'm going to move on to next question. Yeah. Okay. So okay. So I think again, let's play a game, right? Let's come back to Menti, right? Let's come back to Menti. So guys, right? So do you think government agencies should be exempted from the application of the bill? Yes, no, maybe, right? And I think I was just reading the UAE law, right? And it kind of specifically took out all the government agencies, right, from the application of the law, right? So the scope became very interesting there. So they deliberately put it outside, right? They like, I know a lot of times national security becomes paramount, right? And definitely in all those cases, right, I think national security always takes point number one. But yeah, when somebody's trying to abuse it, I think we need to have deliberate controls over there, so the abuse cannot happen for us. I think we all are tilted towards a no. Okay, I think we have like 50% of people have voted, so I think we'll just kind of move on and again talk about a few more JPC recommendations. So I think we kind of still want to kind of talk about the significant data fiduciaries. We're going to talk about regulation of media, right? The social media specific comments that came in. Again, I think because of bots and other things that the government has quoted, but again, it's up for discussion. Penalties, I think the penalties, again, government kind of bracketed the penalty to a bit on the lower side compared to our other comparative analysis of the international laws. And then we have a complaint window. Okay. So I think, again, Pulkit, would you like to kind of take in, a few JPC recommendations and kind of implementation around it, and then probably we move on from this? Yeah.
Sure. So on the significant data fiduciary, not much of the major changes in the recommendation. I would say JPC has just said that, as I mentioned earlier, that the data fiduciary who are providing the services exclusively to the minors are automatically would be classified as significant data fiduciary. Again, I completely agree with what Shashank commented previously, that how would you define that exclusivity? A company would have employees. A company would just provide services to 100 adults, and they would say we are not exclusively catering to. So it would be interesting to see how they define that exclusivity. Other than that, any social media platform with users, I think they are set above a certain threshold, will be classified as a significant data fiduciary. So you know what all companies would be significant data fiduciary. There's no doubt about that. Other than that, they have not made any other comment on what the current draft already says, that it will be based on the volumes of the data processed, amount of sensitive data processed, and other things. And DPA will classify a fiduciary as significant data fiduciary. So just to point out that the data fiduciaries themselves cannot classify them as significant data fiduciary. It has to be the DPA who would do that. On the penalties, as Akash rightly said, JPC has recommended to not go ahead with the penalties that are defined right now, which are around like 5 crore rupees or the 2% of the worldwide turnover. They have not given the new number, so they have said that the new quantification of the penalty will be specified by the way of regulation. So it will be interesting to see if cabinet approves the recommendation, and if it does so, what will be those new penalties, because that's kind of a critical factor for an organization to be afraid of any bill. But again, more than monetary damage, it's always a reputation damage for me, which is more harmful for any organization. On the regulation of media, yeah, they have said, I think that there has to be a regulator to monitor all the social media activities, which is kind of expected, isn't it? Like, we have seen so many news coming in for the last couple of years that this is not a surprise for me, anyways. Around a single window of complaint, so it's kind of they have given a right to the data principal to complain to the authority, and that against any breaches that a data principal foresees happening with a data fiduciary that they have a contract with. So that's another right that they have given, and this is really critical because the companies who are complying with the requirement, who would comply with the requirement, would have to make sure that these cases would arise, and a legal team would have to devise a process mechanism to handle such kind of complaints from
I
the
think
principal.
Pulkit, also, I just want to let both of you in right on this, that we kind of are very close to the time as well, right?
Mhm.
So we just trying to wrap up this and just go into slides quickly and just wrap up this webinar as well, and take in more questions, because we'll just open the session for Q&A now. And again, just a quick vote, guys, on menti.com. So what do you think? Do you think social media companies should be made to establish their presence in India to permit the operation or not? Okay, I think I've got one question and I'm going to pose this question to Shashank. How do you see data localization after after the recommendation as well as the past law? How will it change if let's say the bill becomes a law, right? End of day, then how does it's going to affect the Indian community, the data localization part of the law? Yeah.
I think there would be a lot of investment that will have to be brought into establishing data centers all over the country, which means having physical infrastructure where all of these drives and all of the material and and the physical presence will need to be created. So there certainly will be a lot of job creation and work creation and all of that. And also there would be a massive requirement of electricity, because at the end of the day, all of these data centers are running on electricity to store data. So there would be a huge investment that would be required into infrastructure. And I don't know if we have the ability to do that in such a period of, in a small period of time, because this is physical infrastructure that we are talking of. It's not really virtual, and then there need to be people and entities who are willing to make that investment. So it just might end up coming to organizations establishing their own data centers. A related aspect of this is our telecom regulations, because it's the telecom regulations and those laws which deal with establishing of data centers. And in order to establish a data center, there are a host and a bunch of licenses that are required, and there is a lot of compliance that goes into doing it. So it's not as simple and straightforward as it seems by including some line around this, in the legislation. It will actually, there would need to be a lot of motivation for private sector to do it. And if there are no private sector, or the people who want to invest in it are not sufficient, then it's going to be a huge issue for the country and for companies like us and others. Because if there are no sufficient vendors to provide the service, then that means, and we are obliged by the law to do this, and that means that we would, at the end of the day, need to purchase that particular space at a very, very high rate, or consider having our own captive data center, which are all very capital intensive and cost intensive things to do. And at the end of the day, as I mentioned earlier, is a cost, and the cost is eventually recoverable from the consumers. So it's something that has to be weighed in and thought through fully, because it's not just a privacy issue, it's an infrastructure issue, it's a telecom and a regulatory issue, and bunch of those kind of aspects. Just to put into perspective, just think that, to establish that data center, you require land, right? So there is land which will have to be purchased by someone or leased by someone, and that has to be available, and that has to come from somewhere. So there's electricity which has to come from somewhere. So there's a lot which needs to be thought through before, we make these sweeping kind of changes.
There's a question for you in the chat window. The user is asking whether the new law will interfere with the IT Act 2000. Want to take it up?
So I think it will have to be read in conjunction with the IT Act, and it needs to be seen actually what the new law sort of specified. Because if you look at the Personal Data Protection Bill, that is something which was not squarely within the realm of IT Act, because IT Act said that as an organization, you have a responsibility to protect data. And what that meant practically was just to have a data protection policy, and that's about it. The PDP bill actually went several steps ahead, because it recognized certain rights, personal rights of people over their data and all of that, and sort of gave those rights to people and a mechanism for people to enforce those particular rights. So I would say it's an extension of the IT Act, not in derogation of the IT Act. And I would imagine that the new law, which probably will come after these JPC recommendation, would also be an extension of IT Act and would be read along with the IT Act. So IT Act, it's like a very basic kind of a legislation which governs a variety of matters. So you may not be aware, but it also covers aspects in relation to evidence and electronic evidence. It talks about digital signatures and how they need to be authenticated to be valid. So it touches like a variety and a number of topics, but it's not dealing with personal data and data protection in the level of detail that we are talking of now, because the world has really changed from the time when IT Act was brought into place. So I think it would be complementing the Act and not in derogation of the Act.
I think that was great answers by both of you, right? I think something that I have personally enjoyed as well in the session today, and I can see a lot of questions that we have already taken up. And my suggestion to all of you, whoever is in the audience, guys, just have to do a few things, right? If you scroll up in the chat, you can see our resources for free. You can redeem credits, right? You can join our groups, right? And obviously you can send LinkedIn request to Mr. Shashank and Mr. Pulkit so that you can stay connected with them. Thank you, Pulkit. Thank you, Shashank. Thanks a ton for taking time out, for taking that hour out for all our audience, so that we can get your expert insights today, and help make better help their organization make better privacy decisions tomorrow. Yeah. So Shashank and Pulkit, over to you for thank you. Yeah.
So yeah, again, thanks Akash for hosting me once again. So always an insightful discussion with other panelists and kind of opens up my brain out as well in terms of what I need to do to ensure BT stays compliant with the new law. But yeah, as Akash said, guys, I'm always reachable on LinkedIn. So if you have any questions, any doubts, you can always reach out to me after this session. We still have a long way to go in terms of the data protection bill. These are only just recommendations. They can be accepted by the cabinet, not accepted by the cabinet. And then our draft has to be rewritten on the extent which is based on the number of recommendations which should be approved by the cabinet. In terms of timeline, personally, my opinion, I don't see it happening definitely in the budget session. We just don't have enough time. We possibly see something in the monsoon session, so that's the best possibility I see. And so let's keep all of us keep a close eye on it, and let's work towards making India more privacy mature.
Thank you. Thanks a lot, Akash and Tsaaro team, for inviting me for this session. It was very interesting. Though I follow JPC and all of these things, I looked at it from a very different perspective for this session. So I actually invested some time in reading through and thinking through the recommendations, that what it would really mean for the industry. So it was very interesting for me as well, because in any given day, I'm juggling between 10 to 15 different kind of an issues, and privacy is a very small part of it, if I could say so. I'm not trying to offend all the privacy professionals, but my role is larger than privacy, so I need to be abreast with. So this was a great opportunity for me also to think of these issues and realize that, we just did a gap assessment in the company to sort of fill the gap. And I think this bill will ensure we'll have to do another similar exercise after a couple of years because of this bill, and what the JPC recommendations are, and what it could mean for us. So, but so thanks again for inviting me over, and thank you, Pulkit. It was really nice meeting you and interacting with you through this session.
Yeah. So, yep. Thank you, guys. Thanks a ton for joining in. Right. It's always a pleasure to host such senior people in experience. Obviously, I know, and that is something that we love doing at Tsaaro, and we want to see more and more of you, and we want to take your help in educating everyone around us. So thanks a ton for joining in. Thanks a ton, Shashank. Thanks a ton, Pulkit, and thank you, audience, for joining in. And I hope if I missed any questions, you know where to find me, right? And see you guys. Yeah. Have a nice day. Bye.